Please see where you are. Okay, here you are. Well, Alex Murdaugh, get a new trial. Before I forget, I'm going to redirect because after this, we're going to do a true crime rewind. And we're going to finish, well, I don't know if we're going to finish. We're going to pick up where we left off, but not really. We're going to go above where we left off with Chris Watts. We're going to go prior to that crazy confession with his dad. And that's going to be our rewind, which will be after this Murdaugh video. Okay, I'm just putting the redirect on for after that. And that'll be at 12:30. So, because it's not going to take that long to go over this Murdaugh business here. Hi, J.O.S. So today there was a press conference. I was swimming when all that was going on, but I caught up quickly. And I was unaware that the court clerk had written a book, but she did. She wrote a book about the Murdaugh case, but beyond that, her family has known the Murdaugh family for years. And Buster Murdaugh, not little Buster, okay, but the patriarch, Buster, had been involved with her family with moonshine way back in the day. And so she's heard all about this stuff growing up, but then started to see that there was a dark side. And the whole motion that they filed, and I'll go over the facts, but I'm just going to tell you from what I haven't covered, is the defense, Harpoodle and Jim Griffin, they're saying that this clerk was talking to the juror. Remember the juror that left the eggs and everybody was laughing because they said, "Can I go get my eggs?" that it got dismissed? Apparently, jurors are coming forward like this juror and saying that the clerk was talking to them, and the clerk said things like, "Try to get the verdict back fast." She asked, "What are you leaning towards? Don't listen to any of Alex's testimony. Disregard it. It's all lies." That when the jurors said they had questions and they wanted to know where the guns were, she said, "Don't worry, the guns are never going to be found. Don't worry about that." This is all according to his defense team in this motion, which I'm going to go over. But this is what's happening now. So then they're saying that she went away with the jury foreperson in different rooms, and was speaking with them. And again, rushing for that verdict, and she is the one that read the verdict. But then they said she did this and she just wanted to get to writing this book so she could profit off of this. So that's where the motion is coming from. Now let me get to something over here. Okay. So they're against, the court clerk is Becky Hill. And their filing states that she tampered with the jury by advising them not to believe Alex when she said everything I said was lies. I told you. Persuading them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror that she believed to be favorable to the defense. So they're saying the reason they got rid of that juror was because she presented a case to the judge, and misrepresented critical and material information. Let's see, now this is a quote from the motion. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. Once these two facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. It cites 3 sworn affidavits, including one from a juror and one from a dismissed juror, as well as excerpts from Ms. Hill's book, Behind the Doors of Justice, The Murdaugh Murders, which was published last month. Now, when Harpootlian was asked if they contacted the clerk, he said something like, no, and like, in other words, like, what, she's just going to lie to me again. I'm paraphrasing, but let me see here. Here's another, let's see, another excerpt from the filing. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson, the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. An affidavit from one juror states that Hill instructed the jury to watch him closely and to look at his actions and look at his movements, which the juror understood to mean that he was guilty. And let's see here. So his defense attorneys noted that harmless mistakes occur in any trial, but their argument is that these issues are significant, and saying that the issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury, to secure a financial gain for herself, where a state actor engages in private communication with the jury about the merits of the prosecution. The verdict is impossible to sustain. And then it also goes on to argue that Hill pressured jurors to come to a conclusion in their deliberations quickly. Hill allegedly told them that they would be taken to a hotel for the night if they did not come to a verdict, and did not allow smokers to take smoke breaks until deliberations were complete. It further states Hill furnished false information about a juror to the judge, which resulted in, hold on one second, her being removed on the last day of the trial. Murdaugh's lawyers allege that Ms. Hill targeted that juror as a possible vote to acquit Murdaugh and wanted her disqualified. That's the one with the eggs. So Joe McCulloch is the attorney for the 2 jurors and said they came forward reluctantly with their stories. And I quote him saying, "They have given their best recollections, and now it falls to the court to figure out what to do with this thing. They are serious allegations. The explanation may be less serious." Now, she wrote a tell-all book, Behind the Doors of Justice, The Murdaugh Murders, in which she shares behind-the-scenes details from the trial. In the book, she wrote, she had known Murdaugh for many years in a professional context and was concerned about those relationships given the serious accusations. Here's something from her book. Regardless of guilt or innocence, for me, reconciling Alex's diametrically opposite roles was troublesome, but not something I would allow to interfere with my sworn duties as clerk. Although I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict, I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. She wrote of her surprise hearing the jury's deliberations were nearly complete after only 3 hours. This was unusual. Most murder trials take some time for the jury to reach a decision, but apparently the jurors were satisfied they would be returning to the courtroom shortly with a verdict. I was caught a bit off guard. Let's see. In a recorded call from prison in June, Alex Murdaugh maintained his innocence according to the docu-series The Fall of the House of Murdaugh that is streaming on Fox Nation, saying, "I came to this not expecting anyone to listen to anything. I am not here because of what the jury just convicted me of. I am in this because of pills, stealing, and lying, because I would never, under any circumstances, hurt Maggie or Paw Paw." And that's from a recorded call that's going around in that documentary series. Let's see. So, I don't know. I honestly didn't know she wrote a book. And I don't know. If it's proven that she did these things, then he could get a new trial. But we'll have to see where that goes. I want to see if... Let me see. Let's see what's happening. Well, I'm not in live chat. So let me see. I'll put up a poll while I go get some other stuff here. Okay. And let me go over here and see something. Okay, so let me pull up the actual motion. Get over there. Okay, received September 5th. Appellant Richard, this is a motion to suspend appeal and for leave to file motion for new trial. Appellant Richard Alexander Murdaugh, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves for leave to file a motion for a new trial based on after discovered evidence in the Court of General Sessions and to suspend this appeal during the pendency of the motion. Appellant offers a copy of the motion for a new trial attached as Exhibit 1 with its own exhibits labeled Exhibit A through Exhibit L as the memorandum in support of this motion and documents supporting facts relied upon not contained in the record on appeal as required by Rule 240 of the South Carolina Rules of Appellate Procedure. Exhibit 1. Okay, defendant Richard Alexander Murdaugh, through undersigned counsel pursuant to Rule 29B of South Carolina Rules of Criminal I lost my thing here. Criminal procedure hereby moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Specifically during trial, the Colton County Clerk of Court, Rebecca Hill, instructed jurors not to be misled by evidence presented in Mr. Murdaugh's defense. She told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. Statement of facts. Mr. Murdaugh was indicted for the murder of his wife Maggie and son Paul on July 14, 2022. His murder trial began January 23, 2023. The presiding judge was the Honorable Clifton Newman. The trial ran for 6 weeks, ending with convictions on the evening of March 2, 2023, and sentencing on March 3, 2023. The state rested its case in chief, and the defense began its case on Friday, February 17th, 2023. I honestly can't believe that was the beginning of March, and seemed like it was later into the spring. Court was not held on February 20th, which was President's Day. After returning from the holiday, Ms. Hill began to enter the jury rooms often. Juror number 630, exhibit attached to Exhibit A. As the defense began its case, Ms. Hill told jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." Okay, regarding juror number 741. Additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go into the jury room's single occupancy bathroom together. Foreperson juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors they could not ask foreperson juror number 826 about the conversations. 2 days later, on Thursday, February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told jurors not to be fooled by the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh's attorneys that Mr. Murdaugh would lie when he testified. Understood to mean that Mr. Murdaugh would lie when he testified. Ms. Hill also instructed the jury to watch him closely, to look at his actions, and to look at his movements, which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, foreperson juror number 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former foreperson, juror number 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand, because that is what the defense wants us to do. The next court day after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th, the day Mr. Murdaugh's testimony concluded. While perusing a Facebook group page called Walterboro Word of Mouth, the post purportedly by juror number 785's ex-husband, Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. Folks, I posted an ugly post yesterday, to which I have deleted, and I kinda, in a roundabout way, directed it towards a certain person, and I would like to apologize to everyone who read it that ugly for me to do that. And yes, I let Satan control me, and I broke down and started drinking, and when I was drunk, I made that post, and I'm sorry. Rebecca Hill, Behind the Doors of Justice at 97 Timothy Stone Facebook post, February 16th, 2023. The apology post states the initial post was already deleted on February 16th, so it would have been impossible for Ms. Hill to see the original post on February 24th. Mr. Stone, juror number 785's ex-husband, avers in a sworn statement that he made no such posts. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd, 2023 to March 2nd, 2023, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable at this point under Facebook retention policies, and that he, in fact, never posted anything to the Walterboro Word of Mouth Facebook page during the trial. The person who made the apology post is an unrelated person also named Tim Stone, whose Facebook profile picture is not juror number 785's ex-husband. On February 28th, Ms. Hill questioned juror number 785 about the fictitious post on Walterboro Word of Mouth alone in her office in the courthouse. She told juror number 785 that someone had emailed her stating her ex-husband, Tim Stone, posted on the Walterboro Word of Mouth Facebook page that juror number 785 had been drinking with her ex-husband, and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror number 785 told Ms. Hill that never happened, and that she had not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Ms. Hill would not show it to her. Ms. Hill directly asked juror number 785 whether she was inclined to vote guilty or not guilty. Juror number 785 said she had not made up her mind. Later that day, Ms. Hill told juror number 785 that SLED and Colton County Sheriff's Office personnel went to Mr. Stone's house and he confirmed he made the post. This is a fabrication by Ms. Hill. Ms. Hill told juror number 785 she would somehow reinstate a restraining order juror number 785 previously had against Mr. Stone, which is something that Ms. Hill did not have the authority to do. Sorry, I had to get a drink. Still, later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email. Juror number 785 described her interactions with Ms. Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. He was right to be concerned." The next day, on March 1st, 2023, the jury visited Moselle, the site of the murders, and during the visit, foreperson juror number 826 and Ms. Hill walked off to have yet another private conversation. In her book, Ms. Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the Moselle property. While the jurors viewed the Moselle property, we all could hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew, I knew, and they knew that Alex was guilty. That day, Judge Newman also held an in-camera conference regarding the tenant coworker email in which he decided to revisit the Facebook post issue with Ms. Hill. The court, okay, well, let me see what Becky is talking about. I wanted to revisit the Facebook post that you mentioned yesterday. A coworker of a tenant of juror number 785 emailed the court on February 27th stating that the tenant said her landlord was a juror and had expressed an opinion when delivering a refrigerator to the property more than a week earlier. Ms. Hill, right? The court, that's Becky Hill, the clerk of court. Can you tell us about this Facebook post? Ms. Hill, yes, I think it was Friday evening, just for a brief moment. I perused Facebook, got on Walterboro word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he noticed that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I just kept on scrolling because that was enough for me. I've gotten enough, the court said. And how did you determine who he was talking about? Ms. Hill said. When I heard there was an email on Monday, I figured the two went together, if it was true. Court, well, she's confirmed she has an ex-husband who she has 3 restraining orders out against, so, Ms. Hill, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. But then we found out his name, and we found the post and printed it out where he said that he had put something up, but that he had deleted it at the time, that he had put stuff out there that wasn't nice. The court, he said he got drunk afterwards. Mr. Metters, something about the devil, Mr. Harpudalin. Didn't he say it was Satan in it? Ms. Hill, Satan was in it, yes. In all of the details, yes. The court, all right. Ms. Hill, made me do it. The court, okay, I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got his information from. Ms. Hill, I don't. I can't find it, though. But Ms. Hill never saw any such Facebook post. She's made it up. Further, she knew the apology post was not posted by juror number 785's ex-husband. Juror number 785 showed Ms. Hill a picture of her ex-husband, which is not the Facebook profile picture of the other Mr. Stone's post about Satan. The next day, March 2nd, 2023, the day of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror number 785 asked to speak with Ms. Hill. She told Ms. Hill she was scared. Ms. Hill told her that the Murdaughs probably got to him, meaning her ex-husband. Ms. Hill once again asked her opinion regarding Mr. Murdaugh's guilt. Juror number 785 told her that Creighton Waters' closing was good, but that she still had questions. Ms. Hill asked what questions, and juror number 785 replied that she was concerned that no murder weapon was found. Ms. Hill then asked, "Well, what makes you think he's guilty?" Juror number 785 said Paul's video at the dog kennels. Ms. Hill then told juror number 785 that everything Mr. Murdaugh has said has been lies, and that I should forget about the guns. They will never be seen again. Ms. Hill then asked juror number 785 about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for a raise in hands, this would be over and done with, and everyone needs to be on the same page. Juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court, immediately after the excusal, juror number 785 asked Judge Newman if he had spoken with the clerk of court, referring to the conversation earlier that morning with Ms. Hill. Okay, and then there's a video of the trial proceeding. With that, Judge Newman responded that I have not spoken with her today, and that this is totally independent of any conversation regarding her ex-husband apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them that this shouldn't take us long, and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, as they had previously been allowed to do so during the 6-week trial, but Ms. Hill told them they could not smoke until deliberations were complete. There were 6 smokers on the jury. Ms. Hill told jurors that after the trial, they would be famous, and predicted that the media would request interviews with them. Ms. Hill even handed out reporters' business cards to jurors during the trial. Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a network news show. She traveled with jurors to New York City when they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. A last point about Ms. Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary at the Colton County Courthouse when it was closed for Confederate Memorial Day on May 10, 2023. The film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent a memorandum to the film crew purporting to be an addendum to the contract. A memo from Rebecca Hill, May 9, 2023. In it, she demanded that the film crew pay Colton County a fee of $1,000 per day for use of the courthouse facilities, and made a nonsensical statement about not having authority outside South Carolina that reflects a failure to understand the choice of law clause in the contract. And then she bizarrely added a handwritten demand. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of court for Colton County and author of the book. The film crew ignored her addendum as the contract had already been executed, but like her jury tampering during trial, it was an attempt to violate South Carolina code, which provides no public official, public member, or public employee may knowingly use his official office membership or employment to obtain an economic interest for himself. Legal standard. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury. And in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. When the defendant presents a credible allegation of communications of contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. If the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. In a criminal case, any private communication, contact, or tampering, directly or indirectly, with a juror during a trial about a matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. If not made in pursuance of known rules of the court, and the instructions and directions of the court made during the trial with full knowledge of the parties, the presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the jurors was harmless to the defendant. The presumption is even stronger when the contact was made by a court official, where there was the private communication of the court official to the members of the jury, an occurrence which cannot be tolerated in the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. A state official, Rebecca Hill, the elected clerk of court, had extensive private communication with members of the jury during trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews, testimony at an in-camera proceedings, and other evidence, including Ms. Hill's own book. The court, therefore, must hold a Remmer evidentiary hearing. If the allegations are proven at the evidentiary hearing, then under binding appellate precedent, the court must grant a new trial unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The subject matter of Ms. Hill's communications was the evidence being presented at trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. The court therefore must grant a new trial if the allegations are proven. In a 6-week trial, people will talk when they should not. They will say things they should not say. Mistakes will be made. The participants in a trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of a trial, no verdict would stand and trials would be repeated forever. To avoid that, courts properly strain to find that mistakes made during trial are harmless, meaning they did not change the result. But the issue now before the court are not the ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury. to secure financial gain for herself. Where a state actor engages in private communication with the jury about the merits of the prosecution, the verdict is impossible to sustain. For example, in Parker v. Gladden, a bailiff told a juror in a murder trial, "That wicked fellow, he is guilty." The Supreme Court of Oregon held the statement did not require a new trial because it was shown the statement prejudiced the outcome of the trial. The U.S. Supreme Court reversed, holding the evidence developed against the defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. In this case, the court has declared on the record the verdict that the jury, reached is supported by the evidence, circumstantial evidence, direct evidence. All of the evidence pointed to only one conclusion, and that conclusion, the jury, reached now. The court has therefore foreshadowed the outcome of any harmless error analysis. But the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Miss Hill's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict, even if she coerced the jury to vote guilty at gunpoint, because, in the court's opinion, all of the evidence pointed to only one conclusion: the guilt of the accused. If the strength of the evidence against the accused in the eyes of the court excuses deliberate jury tampering by a state actor, the result is a direct verdict for the prosecution, a structural error. That cannot be the law. Instead, the law requires the subject matter of the communication to be harmless, clearly harmless. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. Hold on one second, because... Okay, I just have to fix something here. Okay. Our Supreme Court recently made this point in State v. Green. Okay, we're not going to go through all that. The Supreme Court affirmed. Telling the jury not to believe the defendant's defense or his testimony when he testifies regards the merits of this case. Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where a bailiff's misleading response to a juror's question about sentencing options compromised the jury's impartiality because it left the impression that the verdict could not affect the trial court's sentencing discretion. Okay. Unlike the honest mistakes of the bailiffs in those cases, Ms. Hill had many private conversations with jurors about the merits of the case. She asked jurors about their opinions about Mr. Murdaugh's guilt or innocence. She instructed them not to believe evidence presented in Mr. Murdaugh's defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty. And she pressured jurors to reach a guilty verdict quickly, so she could profit from it. Each of these actions violated Ms. Hill's oath of office, her responsibility to the citizenry and the judiciary of the state, and Mr. Murdaugh's constitutional right to a fair and impartial jury. The law applied to these facts requires a new trial. For the foregoing reasons, Mr. Murdaugh respectfully submits the court must hold an evidentiary hearing to receive proof of the facts stated above. When those facts are proven, the court must grant a new trial. Respectfully submitted. It's Harpoodle Lynn. Okay. And so here is the affidavit of Juror 630. I was juror number 630 in the case of State of South Carolina versus Richard Alexander Murdaugh. Towards the end of the trial, after the President's Day break, but not before Mr. Murdaugh testified. The clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorney, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, look at his actions and look at his movements, which I understood to mean that he was guilty. Immediately after he testified, the foreperson, juror number 826, said Mr. Murdaugh was crying on cue. The foreperson, juror 826, criticized the former foreperson, juror 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury we cannot interact with Mr. Murdaugh because that is what the defense wants us to do. The jury frequently discussed the case during breaks before deliberations. Towards the end of the trial, Ms. Hill came into the jury room a lot. Ms. Hill and the foreperson, juror 826, had private conversations on multiple occasions. The foreperson, juror 826, would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson, juror 826, would go to another room to have private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson, juror 826, never said anything about the content of the conversation. For example, she never communicated logistical information after those conversations, and this happened 2 or more times, more frequently towards the end of the trial. When we began deliberations, Ms. Hill told us that this shouldn't take long and that if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but were told they could not smoke until deliberations were complete. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from the television show. And here's the next one. Okay. On August 6, 2023, Dick Harpoodle and Jim Griffin and I met with redacted, juror 741. At the meeting on August 6th, redacted indicated she would sign an affidavit. However, we were unable to arrange her a suitable time and place. During the meeting, redacted relayed the following information to us. During the trial, she witnessed the clerk of court, Becky Hill, come to the jury room, and Ms. Hill and the foreperson 826 went into the bathroom. After Ms. Hill and the foreperson exited the bathroom, Ms. Hill told the jurors they could not ask the foreperson questions. Several times during the trial, Ms. Hill told the jurors that the media would want interviews at the end of the trial, and during one of those conversations, she passed out business cards from the media to jurors. At the end of the trial, Ms. Hill told redacted that no one from the media wanted to interview her. Right before the defense put up their case, Ms. Hill told the jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." After Alex testified, 8 jurors indicated they did not believe his testimony. Redacted recalled redacted juror number 544, known as Boston by many of the jurors, was very emotional during the trial. During the visit to Moselle, redacted juror 826 and redacted walked to the scene together, and then juror 826 began walking with the clerk of court, Becky Hill. There were times the jurors were not kept together, but they were in 2 separate rooms. Redacted noticed jurors talking about the case before deliberations began. Neither she nor redacted, juror number 785, joined in the conversations about Alex. As the jury was deliberating, she believes Judge Newman came to the room she was in and told her the jury would have to spend the night in a hotel if they did not have a vote by a certain time, but she does not recall the time deadline. Redacted juror 741 was the first former juror to provide information that the clerk of court made statements to members of the jury about the evidence presented during the trial prior to jury deliberations. Ms. Hill's conduct was corroborated by other jurors during subsequent interviews. Okay, and this is a transcript of records from an in-camera conference. And this is, we went over this in the affidavit about the guy getting drunk and posting that. So it's just that again. And then this is from her book, Rebecca Becky, Behind the Doors of Justice, The Murdaugh Murders. And this is her book here. While Dateline producers were in town for the trial, they asked for Judge Newman's cell phone number, which I was given permission to provide to them. Then Craig reached out to Judge Newman to reconnect. Let's see. What did they want to say in here? As we were cleaning up from after the party, a few of us were asked how we would vote at that point in the trial if we were members of the jury. Before answering, we pledged a cone of silence, and for that reason, I cannot reveal the results of our straw jury poll. What I can say is that many of the party guests agreed with what ended up becoming the actual verdict of the trial. That's a reporter, I guess, talking there about her 55th birthday fell in the trial there. Here she said, working with juries is always a unique experience, and like with any jury, we had some behind-the-scenes happenings with our jurors, the alternates, and the originals for the Murdaugh trial. While most of the jurors were focused and engaged during the Murdaugh trial, we did have one juror who was an alternate at one point who was not. She was more focused on the crowd, who was watching, who was or wasn't following Judge Newman's rules, and so on. For example, she caught a new visitor to the courtroom who was sitting directly across from her, who looked like she might have been taking a picture of the jury, and that wasn't going to fly with her. Then there was the egg lady juror. The juror worked on a monkey farm in the Low Country, and she drove Judge Newman bananas one weekend, pun intended, through the Facebook page. Okay, here she talks about that Facebook page debacle thing. And then it says here, one of the roles of the clerk of court is to be Switzerland between the jury, the lawyers, the public, and any other entities involved. In my opinion, the decision to visit Moselle by Murdaugh's defense team did not work in their favor. They were hoping to show that the proximity was too close for one shooter, and they felt like the pictures didn't show the distance correctly, said Doug Brown, who worked for the defense team during the trial. Okay, and then this is the Timothy Stone Facebook post. Folks, I posted an ugly post yesterday to which I have deleted, and I kinda, in a roundabout way, directed it towards a certain person, and I would like to apologize to everyone who read it that ugly for me to do. And yes, I let Satan control me, and I broke down and started drinking, and when I was drunk I made that post, and I'm sorry. And here's the affidavit of Tim Stone, who says, I am the ex-husband of Redacted. I did not post anything to the Facebook group Walterboro Word of Mouth between January 23rd and March 2nd. I did not post anything on this social media page or my own Facebook social media page about Redacted being a juror, that Redacted was talking way too much to friends and family about the case, or that Satan hadn't gotten a hold of me, and I had been drinking at the time. I posted and was now very sorry. Nor did I post what is attached as Exhibit A, which has been represented to be me, an alleged post to the Walterboro Word of Mouth Facebook page, and a court exhibit in the state of South Carolina versus Richard Alexander Murdaugh trial. I do not have a Facebook page set up as Timothy Stone. My profile name is Tim Stone, and my Facebook page is Redacted. I was never contacted by law enforcement. the South Carolina Attorney General's office, the clerk of court Becky Hill, or anyone at the Colton County Clerk of Court's office about Exhibit A, or a post on the Walterboro Word of Mouth Facebook page concerning my ex-wife, redacted. I did not know redacted was on the Murdaugh jury until I heard her voice on a recording when she was being excused as a juror and she was discussing something about eggs. This is the post again. And this is personally appeared before me, Tim Stone. I am the attorney in the firm of Richard Harpudalin. Okay, on August 18th, 2023, I met with Tim Stone at his home. He provided his Facebook login information and allowed me to download a copy of all of his Facebook activity from January 23rd, 2023 and March 2nd, 2023. A true copy of the download is attached as Exhibit A. The contents of the download speak for themselves, but review of them shows no posts were made on February 16th apologizing for a previous post, and there are no posts whatsoever to the Facebook group Walterboro Word of Mouth. Facebook's stated retention policy for deleted posts is 30 days, so any post deleted in the period January 23, 2023 to March 2nd, 2023 would not be recoverable. And this one, I was juror number 785. During the presentation of the defense case after President's Day, but before Mr. Murdaugh testified, the Colton County Clerk of Court, Rebecca Hill, told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdaugh's attorneys. In late February 2023, Mr. Hill questioned me about a Facebook post on the Walterboro Word of Mouth page. She summoned me to speak with her alone in an office in the courthouse. She told me someone emailed her about a post my ex-husband Tim Stone purportedly made, which purportedly stated that I made comments to him about the guilt or innocence of Mr. Murdaugh. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and that I wanted to hear all the evidence before deciding. Ms. Hill said the post said I had been drinking with my ex-husband and that while drunk with him, I expressed opinions on the guilt or innocence of Mr. Murdaugh. That never happened. And I told Ms. Hill it never happened. I did not go drinking with my ex-husband. In fact, I had not seen him in approximately 10 years. I asked to see the post, but Ms. Hill would not or could not show it to me. I have never seen it, and to my knowledge, no one has. Later that day, Ms. Hill told me SLED and Colton County Sheriff's Office personnel went to my ex-husband's house, and he purportedly confirmed he made the post. She told me she would reinstate a restraining order I previously had against my ex-husband. I did not know about the apology post referencing Satan until Ms. Hill's book was published. I have since reviewed that post and can definitely state that that post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. It does not appear to be a post to the Walterboro Word of Mouth Facebook page. When Ms. Hill first asked me about the Facebook posting purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she always knew the apology post referencing Satan was not posted by my ex-husband. On March 2nd, 2023, the day of the verdict, I received a call from my ex-husband, Tim Stone, as I was getting on the bus to travel with the rest of the jurors to the courthouse. I did not answer. The phone call upset me greatly, and I asked to speak with the clerk of court, which I did by telephone using bailiff's Mr. Bill's phone. I told her I was scared. She said the Murdaughs probably got to him. Ms. Hill then asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Creighton Water's closing was good, but I still had questions. She asked me what kind of questions, and I replied, questions about the guns. She asked, what would make me think he is innocent? I stated that no murder weapon was found. She then asked, well, what makes you think he's guilty? I said, Paul's video at the dog kennels. She then stated that everything Mr. Murdaugh has said has been lies and that I should forget about the guns. They will never be seen again. Miss Hill then asked about the views of the rest of the jury. She told me if the foreperson would just go in and ask for a raise in hands, this would be over and done with. She said everyone needs to be on the same page. She then again said she would reinstate a restraining order I previously had against my ex-husband, and that she would call Judge Newman about the restraining order. I then went to the jury room. Approximately 10 minutes later, I was excused from the jury. During the proceedings, I asked Judge Newman if he had spoken with the clerk of court. He only said, this is not because of your ex-husband. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post he purportedly made because I knew I had not made the comments he claimed I made. He emphatically denied ever making any such Facebook post and genuinely seemed not to know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, redacted juror 864 and redacted juror 826 were in the single toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case. Redacted juror 729 referred to it as A and D time. In the van going to the courthouse, redacted juror 864 and Special Agent David Owen said Special Agent David Owen lied on the stand, but that nothing would happen to him. When we visited the Moselle crime scene, Ms. Hill and redacted juror 826 walked off together, avoiding other jurors in order to have a private conversation. I own a rental property, which is leased to 2 tenants, Deborah Webb and Clifford Dandridge. On Saturday, February 18, 2023, I delivered a refrigerator to the property. I was removed from the jury on the day of the verdict because a co-worker of Ms. Webb purportedly said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Ms. Webb then worked at Domino's Pizza in Walterboro, so the co-worker would be some employee of Domino's Pizza in Walterboro. I do not know whether Ms. Webb actually made any such statement at Domino's Pizza or whether a co-worker actually heard any such statement. After I was dismissed from the jury, I spoke with Ms. Webb and Mr. Dandridge, who both vehemently stated to me and my husband that the affidavits the prosecution drafted for their signature was not what they said to him. They told me Sled showed up at their home at 10 p.m. after they were asleep, removed them from their home, put them in separate cars, and questioned them. Mr. Dandridge said he told them I did not say anything about Mr. Murdaugh's guilt or innocence. Sled returned 30 minutes later again, woke them from their beds to serve subpoenas on them to appear in court the next day. They arrived at the courthouse at 9 a.m. the next day, and they were held for 9 hours until 6 p.m. when Sled officers or a prosecutor finally presented typed affidavits to them saying they were their statements from the previous night that had been recorded by dash cams in the patrol cars. They said they signed their affidavits without reading them. As I previously testified, I never discussed the merits of the Murdaugh case with Mr. Webb, Mr. Dandridge, or any other person present, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator or during any other interaction within them during the trial. Okay, now this, what is this? draft transcript of records from the in-camera conference February 28th. Have you put anything on Facebook? Juror, not regarding the case. I put a positive post on. I gave Miss Becky my full access to my Facebook. I put positive posts on. I've done that for the past 3 years, but court says, has anyone posted anything on Facebook about you? And juror says, I wasn't aware of this until Miss Becky told me today. Court says, what did she tell me? Juror says, she asked me if I had an ex-husband, and I said yeah, and she asked me if I talked to him about the case or being on the jury, and I said no, and I questioned her why she was asking me that. I haven't seen my ex-husband since 2014. The court says, does he live in the area? Juror says he does now. He lives in Cottageville. Court says, okay. Juror says, and I have 3 restraining orders against him. Warning. Court says, so he's basically up to no good. The juror says, I wouldn't say that. I'd say a lot worse, but that's a nice way to put it. Excuse me. The court says, okay. The juror says, but she told me that. I was very upset after she told me that. Like I said, I have 3 restraining orders against him. I wouldn't have anything to do with him if I didn't have a child with him, but I haven't seen him since 2014 when we got a divorce. I have talked to him within the last year because I got a call at work that my son was in jail and needed a ride home, and I did call his father and asked him to go get him, which he did not do. But other than that, I have not seen him, talked to him, or anything else since 2014 other than getting restraining orders in Colton County, 1 in Orangeburg County, and I have 1 in Berkeley County. The court, wow. Juror, but Ms. Becky said she had went to look for that post again and that it had been deleted. And I don't know who she talked to or anything else, but she said apparently, court says, when did she tell you that? Juror says, it was after you let us go on that last break. I was very upset. And she came down and talked to me and said that apparently, I don't know who talked to him, but said that he was drunk and he removed the post. Court says, so has she discussed the case with any of the jurors? Has the clerk discussed anything about the case with anything on that jury? Juror says, not that I'm aware of. The court says, okay. She was just discussing with, juror says, she just pulled me aside and we went downstairs after the last break. I want to say it was after lunch and we came back, and that's when she first told me about it. And then when we went back into court, I was kind of screening the audience to make sure that my ex wasn't out there. And she came downstairs after that break and told me that she had found out that he was drunk and made a drunk post. And I don't know what happened from there. I have no clue. Court says, and you work at the, juror says, I work at a monkey farm. Court says, monkey farm? What do you do there? Juror says, I work in the lab. For the lab, all I do is watch monkeys. It's a testing facility where they try and come up with cures for like AIDS, cancer, leukemia. Court says, you're happy to be here, away from the monkeys for a while? Juror says, yeah, I miss my monkeys. The court says, are they pretty smart as everyone says? The juror says, they are very intelligent and they hurt and bleed and have feelings just like you or I do. They do. The court says, okay. At this point in time, have you made up your mind as to guilt or innocence, though? Juror says, I haven't. I was trying to wait on closing arguments because those are usually pretty good. The court says, you've been on jury duty before? The juror said, I was, but it kind of really sucked because they called us back and we were, anticipating. It was my first jury and they made up an agreement and we never got to sit on the jury. The court says, okay, any questions either for anyone to ask? Mr. Griffin says, no, Your Honor. Mr. Waters says, no, sir. The court says, okay, if you will stand right inside. Juror says, follow her. Court says, follow her for a second. Gabby just right outside, inside the other door, but not all the way out. Juror 785 exited the room. The court says, all right, comments. Mr. Griffin says, Your Honor, I think that satisfies it. And she hasn't talked to anybody, hasn't expressed an opinion, and hasn't made up an opinion. And she's got an ex-husband that she has 3 restraining orders against him. The court says, that's understandable. Have a good night. Juror says, thank you. The court says, okay. Juror says, they are going to bring me back to my car, right? The court says, they didn't leave you, did they? Juror says, yes. The court says, oh, they did? The law clerk says, no, I'll go get her to a bailiff, and they'll go get her. I'll go down there to a bailiff. Juror says, they left. The law clerk says, and make sure they get her home. Juror says, y'all have a good night. The court says, okay. Mr. Griffin says, bye. The court says, well, Mr. Waters says, I got a name now. The court says, a name. Clifford Dandridge, B Street. Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. Mr. Griffin, I was surprised to hear that. The court, yeah. The court, so. Okay, and this is an affidavit of H. Miller, juror number 326. They left her name on here. If they didn't redact that, that's good. On August 6th, Dick Carpoodle and Jim Griffin and I met with. See? Why would they do that? Now they're redacting it over here. Isn't that crazy? Redacted juror number 326 in the case of the state of South Carolina versus Richard Alexander Murdaugh and his mother at her home located at redacted. During the meeting, juror 326 relayed the following. Juror 326 was asked if Ms. Hill told the jurors not to let the defense mislead them. He did not specifically recall the statement, but he did recall that Ms. Hill commented to him and the other jurors about the photos that would be admitted into evidence, indicating that the images would be disturbing. Juror 326 also stated that the jurors were stationed in 2 separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. He was not in the same room as jurors 630, 741, 785. Juror 326 stated that Ms. Hill would visit the other room more often and that he could not hear what she was telling the jurors in the other room. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside of the jurors. He further commented that some of the jurors were going into their office because of financial reasons and that people were talking to coworkers and because coworkers wanted info. Before deliberations began, 326 indicated that minor conversations led him to know who was a yes and who was a no. That rhymes. His vote changed with new evidence. As the jury was deliberating, the bailiff and Ms. Hill told the jurors they could not take a smoke break during deliberations. There were 6 smokers on the jury. After the trial concluded, a group chat was formed with the jurors, but juror 326 dropped off of the group chat because there were too many chats. When asked if he thought the clerk of court, Becky Hill, was inserting herself in the process of the trial, juror 326 responded, I can see this. And a memorandum from Rebecca. This is to DreamWorks, aka Texas Crew Productions. Dear Redacted, I'm looking forward to your upcoming docuseries on the Murdaugh case, and I hope you'll be able to use some of my interview should you choose to. Because I am an elected official, we'll need to modify 3 clauses in the location agreement you presented me, as it relates to my authority. Please change the word owner to Colton County in every reference in the agreement. 3. Dates and location fee. Low County Story LLC agrees to pay the Colton County Treasury a fee of $1,000 per day for use of the Colton County Courthouse facility, so as long as it does not supersede any court proceedings. Payment will be made by the close of production. Miscellaneous. Colton County, South Carolina can only enter into a legal agreement for services if it is to be governed here in South Carolina, not New York. As an elected official, I have no authority outside of the state of South Carolina. Sincerely, Rebecca Hill, Colton County Clerk of Court. Rebecca Hill, she signs. Rebecca Hill, she initials. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video audio clips will accompany the usage on the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as Clerk of Court for Colton County and author of the book. Okay, and that's it. So let's see what your poll says. So look at that. That's really, really close. It says 52% yes and 48% no. And after reading that, if, you know, it looks to me like they're going to have that evidentiary hearing, but if that is proven, well, you probably will get a new trial. I don't know that the outcome will be any different. I don't think it will be. But it'll just go and cost more money. Hi, video reel. So now 53% say yes. So if you haven't voted, get your vote in. If you haven't put your likes or dislikes on the video, do that. We are late moving. We are a half an hour late moving to our next video, but that's okay. Sometimes you've got to be late. This is going to redirect you. We're going to do a true crime rewind. Chris Watts. The last true crime rewind we did on Chris Watts had us at that after the lie detector when Tammy delivered the news that he failed the polygraph, and then to the whole situation that was thrown out, the scenario about Shanann hurting the kids, that then Chris and his father ran with. Okay, but we're going to go before, and we still have to go after. That was kind of a chunk in the middle that we took. And then we listened to the phone calls with his parents at the jail. So we're going to go to do a rewind, because we want to do facts, not conspiracy, not fluff, not let's write our own story. All right, so I'm going to end this. Thank you for watching this, and I'll meet you over there.